like to first introduce us. So we are KPA lawyers, and my name is Ivana. I'm going to be one of the lawyers presenting this evening. And alongside myself, we have our other associate, Adil. So Adil, say hi to everybody.
Hey, everyone.
And our licensed paralegal, Francis, who's very excellent. Francis, you can say hi.
Hey, everyone. How are you?
Okay, so tonight we're doing a webinar which is entitled Employment Law, and I've entitled the presentation, which I'll be sharing in just a second, Employment Law for Pandemic Times. And while this seminar is going to be focused primarily on employment law as it applies to employees, there's obviously concepts that employers, small business owners can take away from this as well. And so we'll be going through that this evening. So 6:31 now, I'm going to get started with the slides, and then I wanted to let people know that at the end of the presentation, we've left some time for Q&A, so if anybody has any specific questions, or if any questions come up while you're going through, or while we're answering, or while we're giving the information, you can submit a question through the Q&A function on the Zoom there, and then we'll make sure that we answer them, and at the end, we've left time, so if keeping in mind that we're not able to provide legal advice necessarily, but we hopefully can provide some information for you that will help you in making your decisions. Okay, so Francis and Dill, can you just confirm that you're seeing the right webinar up right now?
Yep.
Okay, great. So as I said, we've entitled the presentation Employment Law for Pandemic Times. So tonight we're going to be talking about employment law as it's changed during COVID-19 and things that have stayed the same during COVID-19, which also includes your responsibilities and your rights as an employee in Ontario. So again, the hosts tonight are Adil, Francis, and myself. So our agenda for this evening starts with general notes. So this is just kind of a caveat, things that are good for you to know when going into the employment law seminar that we're going into tonight. Then we're going to go to part one, which is layoffs, terminations, and leaves. So that's kind of the header topics there, but it's going to be generally about employment law. Myself and Francis will handle that. Then Adil will take on workplace health and safety laws. I'll cover human rights and the duty to accommodate. We'll go back to Adil for benefits and replacement income, and then we'll hit the Q&A section. So just quick introductory notes. So we're all now familiar that a state of emergency has been declared in every province and territory. There's workplace closures still occurring across the country, although we're at a point now where a lot of workplaces are also reopening. We're still at an over 20% national unemployment rate, which hopefully will reduce. So how has everyone been surviving? We hope that you have been. And tonight we're going to teach you how to survive. So the headliner items that you need to know to survive are to know your rights, to stay safe at work, to take care of yourself, to access benefits, and then ultimately get you back to work. Okay. So now jumping right into the employment law for employees. So as I said, terminations, leaves of absences, temporary layoffs, and something called wrongful dismissals, which Francis will cover at length. And the important first caveat, as all good lawyers do, we have three specific caveats here. So the first one is, while we're talking about your general rights at law in Ontario, if you're a member of a union, you should refer to your collective bargaining agreement or your collective agreement. It may give you more rights or different rights than the ones that you have at law, or the ones we're discussing here. It can't take away the rights that you normally have, but it can expand on them. The second caveat is if you are a federally regulated employee, your rights may also differ slightly since you are governed by the Canada Labour Code rather than the Employment Standards Act. Federally regulated employees is a whole category of people. It includes things like people who work at airports, people who work in mail, people who work in cross-border transportation, logistics potentially. It just depends. You should be able to ask an employer or see from your employment contract if you are federally regulated, and then if not, there's always a way to look it up. And lastly, while we're emphasizing Ontario's laws and the Ontario Employment Standards Act, the laws of other provinces or territories about these kinds of things is likely very similar. And the reason being here is a lot of our governing common law comes from the Supreme Court of Canada, so it applies all across Canada.
Hey, sorry, Ivana, just to jump in. Your slides, I think, are, it's not full screen. It's got the next slide and notes showing, so maybe you just want to switch to the full screen view.
Thanks, Adil.
No worries.
How's that?
That's much better.
Okay. Sorry about that, didn't realize. It's harder to tell from the inside of what screen I'm sharing since I've got two up right now. Okay, so moving on to the difference between the Employment Standards Act and the common law in a broad scope. The reason that I'm covering this, the Employment Standards Act versus the common law, is because there are simultaneously two bodies of law that govern your employment and provide you rights and impose obligations on you in Ontario. So it's both at the same time. So both the Employment Standards Act and the common law, judge-made law. So the Employment Standards Act provides you with your basic rights. These are the minimum things that you must get from your employer. It's, so to speak, the floor. They can't give you any less than what the Employment Standards Act says you're entitled to. And then common law, which is judge-made law or courtroom law, gives you expanded rights normally. So it'll raise the floor in some cases. Examples of things that are governed by both sets of laws include termination and notice periods, vacation pay and vacation leave, as well as sick time. And I believe Francis is going to be going into the common law around termination and notice periods. So we'll get a little bit more expanded around that. And I have a note here that says, how do I determine what my rights are now? Well, you start with the Employment Standards Act, and then the best piece of advice I can give you, short of contacting a lawyer specifically or a paralegal to ask about your rights, is look for articles from Ontario law firms about the specific topic that you need. They should be able to point you in the right direction. Okay, so I'm going to talk about leaves and leaves of absences, and then Francis is going to take over with what happens if you're not placed on a leave after that. Oh, as well, I'll deal with work sharing as well. Okay, so the first thing that's changed with respect to leaves and leaves of absences during COVID-19 is that there's been an expansion of emergency leaves. So an emergency leave is a right that's extended to you as an employee that allows you to take a leave of absence from work in a fashion that's called job protected. So what that means is your employment with your employer is still secure, so you're not fired, you haven't been deemed to quit, you haven't abandoned your job, nothing like that, because you're incapable of coming to work due to the emergency declaration. And it's called protected because you can't be fired, but it's also an unpaid leave, which means that while your employer can't terminate you for not showing up, they're at the same time not required to pay you. So you're just entitled to be rehired once the leave is over. Other leaves of absences that are available to you under the Employment Standards Act are all of the leaves of absences that are normally available to you. So that hasn't changed. The only difference is there's this expanded emergency declaration leave. So some examples of leaves of absences that you're entitled to as an employee under the Employment Standards Act are a leave of absence from work for pregnancy, leave of absence for sick, so stress leave, long-term disability leave, those kinds of things. Parental leave, which is the leave that you take after you've had a child or adopted an infant, something like that. Family medical leave and family caregiver leave, bereavement leave, child death leave. There's lots of other types of leaves under the Employment Standards Act. Those have all stayed the same. So options that your employer has probably been exploring in order to keep themselves active, keep you sort of at work, and keep themselves otherwise profitable and operational during the pandemic are options like workforce reductions, temporary layoffs, reducing your hours of work and your wages, possibly changing your job duties. Francis is going to talk about the reductions in hours and wages and how that may impact you and how the law sees those things. One thing I wanted to point out is an option that employers do have is to have you, your employees, or if you're part of a union, have your union agree to a work sharing program. So a work sharing program is a program which is co-funded by the government of Canada. It's kind of a wage top-up that the government gives in exchange for a group of employees known as a work share unit or a WS unit who agree to reduce their hours of work by a certain percentage altogether. So this means that, let's say a group of 5 of you normally work 40 hours a week, and the employer comes to you and they say, we just don't have enough work available for you to work 40 hours a week anymore. If you all agree to, and we'll have to fire one of you as a result to keep the rest of you on staff, if all 5 of you agree to reduce your hours by, let's say, 10 hours a week, so everybody now has 30 hours a week, you and the employer, if you enter into a voluntary agreement, can then get help from the government of Canada to have your wages topped up by a certain amount. So eligible employers are year-run year-round businesses in Canada that have been around for at least 1 year and have at least 2 employees in a work-sharing unit. And to be an eligible employee, you have to be a year-round, permanent, full-time, or part-time employee needed to carry out the day-to-day operations and functions of the business. So this means seasonal employees, students, casual, on-call, co-op, temps. Those ones don't qualify for admission to a work-sharing unit. It also can't be anyone who's self-employed or a director of the employer if the employer is a corporation. The biggest change that's come out during COVID-19 about work-sharing agreements is, number one, they can be re-implemented. So at a workplace where they've been implemented before, immediately, rather than waiting for government approval, which is typically what's required. And then the maximum duration has been extended from 38 weeks to 76 weeks. And it's also changed the kinds of industries that can apply for it. So I have an example here of how the top-up works, and it's exactly what I sort of outlined before. So let's say that Adil here usually works 40 hours a week and earns $500 per week. But now because of the work-sharing agreement, Adil worked 30 out of a possible 40 hours this week, which means he's lost 10 hours of his, and so he's lost 25% of his time. So he gets 25% benefit rate. So that means he gets a top-up equal to the amount of time that he's not been at work for. Okay, and that's it for my portion of the employment laws. Francis, I believe the next section is all you, so I'm going to let you take over now.
Thank you so much, Ivana. So yeah, speaking more in length as to reducing hours. So possibly reducing hours may lead to something called constructive dismissal. So if an employer unilaterally, meaning without the employee's consent, either or without the employer, without the employee's voluntary agreement, it may be seen as a constructive dismissal. So this is a unilateral decision by the employer to determine and change the employment contract. So an employee who experiences the significant change in their employment, such as hours, which also include possible wages, any sort of job duties. So say if you're a supervisor, you've now been demoted into maybe a clerical employee. This can be seen as a drastic change in the employment contract. So in terms of these, sometimes they may be agreed to that previously and maybe stated in the employment contract. So if you sign an employment contract, maybe it's been agreed to by you signing this, but at the end of the day, you do have to check your employment contract to see if any agreement was made between you and your employer. So what do you do if you can't afford to keep, sorry about that last part, in terms of your employees? Like what if your employer comes up to you and may have to temporarily lay you off? What happens in that case? So I will be addressing that in a little bit. Ivana, next slide. So other common forms of constructive dismissals are, like I said, reduction of hours and wages, unlawful demotion. So if you're a supervisor and you've been now demoted to a clerical employee, harassment by other employees or managers. So we hear sometimes stories about a coworker or colleague may have been harassed at work. It doesn't necessarily have to be from an employee. It can also be from a manager and vice versa. Increased workload is another common form of constructive dismissal, where the employee has began to do more work than what has been initiated in the employment contract. Generally, employment contracts have something called job duties, specific job duties. So in this case, sometimes an employee may be given more jobs and specific duties. Workplace changes is another one. If you are situated, if your employment is supposed to be only in one location, and your employer comes up to you and tells you to move to a different location, this could be seen as constructive dismissal. And the most common recently is the temporary layoff rule, which I will now address. Next slide, please. So what is a temporary layoff? So as previously mentioned, Ivana talked about the Employment Standards Act giving minimal rights to employees and employers actually as well. So Section 56 determines what temporary layoffs are. So a layoff of not more than 13 weeks at any 20 consecutive week period is what is considered a temporary layoff. So your employer cannot lay you off for more than 13 weeks. But there is also a possibility that they actually can, which, as as you see on screen, can be extended for up to 35 weeks at a period of 52 consecutive weeks. So we are coming up to the point where temporary layoffs may be getting up to that 13 weeks if you're an employee who is still currently temporarily laid off. What happens after the 13 weeks? So they can extend for up to 35 weeks, but must adhere to specific conditions such as continuation of any health and dental benefits, any possible pension contributions, substantial pay, which there is an exhaustive list in the Employment Standards Act. So after your a temporary layoff is essentially it's temporary. So the employer does have something called a duty to rehire. If the employer doesn't rehire you after the temporary layoff, it could be seen as a constructive dismissal. And in terms of the temporary layoff, it's not necessarily that the employer can tell you that you have been temporarily laid off. It actually has to be in the employment contract. If not, it can be seen as a unilateral decision by your employer to temporarily lay you off. Next slide, please. Bottom, next slide. Thank you. Sorry, Ivana, is there a slide in between? Yes, this is the one. This between CERBs and CEWS. That's it.
No, so there's no.
Oh, is it? Sorry guys for the technical difficulties. We will get these slides back up in a moment.
So I was just checking, Francis, and there's only the two there. So there is what is a temporary layoff, and then Qs and CERB. Yeah, what was the next slide supposed to be?
It was supposed to be the Qs and CERB one. That was the next slide after temporary layoff.
Oh, okay. Well, I think that we can probably make that happen. So here, let's just open that one back up. So it's supposed to be this one, Francis?
Yes. Thank you so much. Sorry about that, guys. So for employees who have been temporarily laid off and their employer may have recently came up to you and said, oh yeah, we're going to rehire you, they are possibly going to be rehiring under the new Qs, the Canadian Emergency Wage Subsidy Program. So under this program, employers are allowed to rehire employees and back pay any employees who have been temporarily laid off. The employer will be eligible for the subsidy for any of the retroactive pay that they have to pay their employees. So if you're an employee and have been rehired and retroactively paid, this may impact you as you do not now meet the revised eligibility for CERB. So if you don't meet the revised eligibility for CERB, most likely you will have to pay CERB back. Adil will get more into the eligibility requirements, but for now I'll just speak about the implications this may have if you are rehired and you do have to repay. So it hasn't been determined exactly, but most likely the CRA will induce fines, penalties, or any other tax liabilities if a specific person who was not eligible for the CERBs program did receive the funds. Additionally, as Ivana spoke about earlier about the Workshare program, if you do get rehired and Qs is in play, this may impact the Workshare program. Next slide, please. So as previously mentioned, one of the consequences of being recalled to work is the repayment of the CERB if you become ineligible. Additionally, if an employee voluntarily refuses to return to work, may be seen as abandonment of job. So what may happen is that if you're an employee and you have been rehired and you refuse to return to work, this could be seen as a abandonment of job, which is something called a just cause dismissal, a reason that your employer can terminate your employment. There are caveats to this, such as refusal to return to work for unsafe work, which that's under the Occupational Health and Safety Act. Adil will address that later on. But in addition to that, employers must readjust the record of employment, your ROE, when returning to work. So another big concern about temporary layoffs is that even though you're being recalled to work, this may not mean you actually get your job back. Sometimes an employer may rehire you and then terminate you because they need to reduce overhead expenses, reduce staffing, eliminate certain positions. So if this ends up being, if an employee ends up being in this position, is there any legal recourses? Next slide, please. So in terms of this is what we call in law a wrongful dismissal or a dismissal without cause. This is when an employer terminates an employee without reason and without notice or pay in lieu of notice. So what is notice and what is pay in lieu of notice? So what notice is that the employer has to provide a certain amount of days or weeks or even months in terms of them terminating your employment. So this is generally governed by the Employment Standards Act, which provides the minimal rights for employers and employees in Ontario, which I will get to the specifics about what the Employment Standards Act says. So I previously mentioned just cause dismissal, so such as abandonment of job, possibility of employees being terminated for harassment. Those are something called just cause dismissals, which employees will not be entitled to the same rights as an employee who's been terminated without cause. So a lot of the employers, because of the orders for non-essential services to close and shut down, they've had to reduce their employees or even terminate or temporarily lay off employees. So what are your rights in this case? Next slide, please. So as previously mentioned, how much notice or pay in lieu of notice do I need to provide the employee as you are the employee? So Section 57 governs employee notice periods, which is very rangy. It can be, if you've been working for your employer for 1 week, 1 year, sorry, you're entitled to 1 week. If you've been working for more than 1 year, but less than 3 years, you're entitled to 2 weeks. If you've been working for 8 years or more, you're entitled to a maximum of 8 weeks. The Employment Standards Act outlines this very well, and these are minimal rights under the Employment Standards Act. So as talking from an employer side, so if I've terminated Johnny's employment due to the non-essential service closures, ordered by the provincial government, Johnny has been working for me for 2 years. According to the ESA, he would be entitled to 2 weeks notice. So now we see that if I needed to terminate Johnny, he'd be entitled to 2 weeks because he's been working for me for 2 years. Alternatively to the Employment Standards Act, as Ivana has previously mentioned, there's something called common law, which I will now address. Next slide, please. So the common law takes the approach of what an employee would have earned if the employer provided reasonable notice. So reasonable notice has been discussed, like what is reasonable. So there is a case that has provided what would be reasonable notice if an employee has been terminated for without cause. So they're based on 4 specific factors: how old you are, the length of service, how long you've been working for your employer, the characteristics of your employment, such as whether or not you are in a supervisory role or if you're a clerical employee, and as well as availability of other similar employment. So once you have been terminated, what kind of jobs out there are available? So there has been a rule of thumb where it's 1 month. For every year of service, you're entitled to 1 month. So an example, as I previously mentioned, if I was an employer, my employee Johnny was 48. He worked for me as a bar manager at my restaurant for 2 years. So incorporating the 4 factors that I previously mentioned, he could possibly be entitled to anywhere between 2 to 3 years, 2 to 3 months of reasonable notice based on the 4 factors. Next slide. So how do I determine if I'm entitled to the 2 weeks under the Employment Standards Act or the 2 months in terms of Johnny's case? So the best thing to do is check your employment contract. Does the employment contract have a termination clause? Was the contract verbal or written? Employers may be at risk for a lawsuit, so therefore there may be possibility to be able to sue at common law. Next slide, please. So post-termination rights if wrongfully dismissed. So if you are in a situation where you believe that you've been wrongfully dismissed, the most obvious is the termination pay and or severance pay at common law or ESA, dependent on your employment contract. Other termination rights include the continuation of health and dental benefits, vacation pay that is owed or still that should be owed during the reasonable notice period, and the ability to vest stock options and any other compensation that's in your employment contract, such as if you received a car or if you received something called car allowance, you'd be entitled to that as well. So what if you have been terminated with cause, or for cause, sorry? There's less rights generally, and it would mainly be stuck to just vacation pay if it has not been paid out. So what if my employee terminated me for, or what if my, sorry, not what if my employee, what if the, I've been terminated for cause, but I barely believe that I was terminated without cause. What are my options? Next slide, please. So the roots of legal action. There's different ways you can begin a legal action against your employer if you feel like you've been terminated without cause. The most common one is starting a claim at the Superior Court of Justice or Small Claims Court for wrongful dismissal. In addition, employees may file a complaint with the Ontario Ministry of Labour for failing to provide reasonable notice under the ESA. The caveat for this is that you can't do both. It's either you apply, you start a claim at the Superior Court of Justice or Small Claims, or you file a complaint with the Ministry of Labour. And in terms of the Ministry of Labour complaints, it doesn't necessarily have to just stick with just a reasonable notice. It can also be for any unreasonable denial for leave, failure to pay wages, and so on and so forth. So once once you make a complaint to the Ministry of Labour, an employment standard officer investigates the complaint, and if the employment standards officer determines that the employer did violate the Employment Standards Act by failing to provide reasonable notice, failure to pay wages, the employer will most likely be ordered to pay and also possibly face any fines under the ESA. Other avenues of legal actions can also be taken by filing a human rights complaint, which will be addressed a little bit later on, and as well as a complaint to an occupational health and safety officer for refusal for work for unsafe work. So another area where employees may be able to make a complaint is that if you're unionized, so if you're a unionized employee, check your collective bargaining agreement and then possibly file a grievance with your union representative. And then if for any reason your union representative may not be doing the best job that you feel, you may also file a complaint with the Ontario Labour Relations Board. And that is it for my part.
Thanks, Francis. So, Francis, it's going to be a deal with the workplace health and safety portion. But before we move on, we did receive an email from one of our participants asking a question. And the question is, what is the law around what it would cost to fire an employee without cause or with cause when we don't have an employment contract with that employee? So I think right now might be a timely time to just retouch on that topic.
Yeah, if you want, we can go back to the slide, or I can just talk about it. ESA versus common law, I believe that would be the best one.
Okay.
So here we are. So the question is that if you need to terminate your employee, but there is no employment contract. So if there is no termination clause, well, there is no employment contract, or the contract is verbal, therefore there is no termination clause, and it can be a possible lawsuit for suing your employer at common law, which previously mentioned is a greater amount in terms of reasonable notice for the employee, if that were the case. So that's the key difference between if there is an employment contract that states any termination provisions and the rights when someone is terminated either with or without cause.
Okay, I think that covers it. And then obviously, if we've covered what the repercussions are if there's possible legal action that the employee wants to take. So I assume that the employer will be capable of extrapolating from there. Okay. Thank you very much, Francis, for answering that question. And again, if you have any questions as we go, you can use the Q&A function. I've answered a couple as we've gone. So now we're going to be moving on to Adil's section of his first section out of two, which is health and safety obligations and rights during COVID-19. So Adil?
Thanks, Ivana. So as the province opens up and people return to work, one of the things that may not have been a factor previously in your workplace, if you were in an office environment, for example, are the health and safety obligations, particularly under the Occupational Health and Safety Act or the Canada Labour Code. So, moving forward with respect to COVID-19 now, this is going to be a serious concern for several people returning back to work. And I'll just run through the agenda, which is on the next slide. So first, I'll just give a brief overview of the Occupational Health and Safety Act and other legislation that's in play. And then one of the things that employees, are really concerned about going back to work is the right to refuse work and the reasonable basis for refusing work. And of course, with the overlay of COVID-19, what that constitutes. And of course, I'll be ending off with the process for investigations and remediation with respect to a complaint or a concern in the workplace. Next slide, please. So just a brief overview. Each province has legislation for occupational health and safety. It provides a legal framework for making workplaces safe and a healthy environment. Of course, for federally regulated employees, it's under the Canada Labour Code. And so under both jurisdictions, you're looking at duties of employers and supervisors, owners, if you're on a construction site, whether you're a supplier. And it also looks at your rights to refuse unsafe work where either the operation of equipment is unsafe or the workplace itself is not safe to you with respect to COVID-19. Next slide, please. So under the Occupational Health and Safety Act or the Canada Labour Code, you do have the right to refuse work. The enumerated grounds are typically where you can refuse if the operation of a machine constitutes danger, or if the workplace itself is unsafe or dangerous, or a specific activity that you are required to perform is a danger to yourself or another employee. Now, there are exceptions, and it's typically where your refusal would put the life, health, and safety of another in danger. Typically, you'll see that with nurses, doctors, firefighters, policemen, their jobs, and which also comes under the second exception, which is the danger itself is a normal condition of your employment. So again, nurses. And typically what the rule has been is that workers are entitled to refuse work where there's a reasonable belief that they would be endangered. Now, this is fluid depending on the jurisdiction that you're in. And what I mean by that is if you're under the Occupational Health and Safety Act of the province, typically Ontario and Quebec have a threshold where there is a danger as opposed to a mere risk. Now, of course, in British Columbia out west, it's different. The threshold is whether there is an undue hazard. And of course, the Canada Labour Code, which also has its own jurisdiction, their threshold is merely the existence of a danger. So depending on what jurisdiction you're in, the threshold requirements do vary, okay? And one of the main things that they do look at, irrespective of the jurisdiction that you're in, is that the reason for the workplace being unsafe, it is specific to that workplace. So it's a very factual exercise that you're looking at. Next slide, please. So typically you'll be looking at Health Canada's guidance, especially as people return to work and the province opens up different sectors. Previously with the SARS cases, you know, where people were or staff were refusing work, the threshold was not met. With COVID-19, of course, this is a completely different disease, and of course there are measures in place, as many of you have seen, with respect to grocery stores and whatnot, having distancing measures put in place. Personal protective equipment is supplied, and of course sanitation is also required. So whether or not it's sufficient for you to refuse work once you do return, it's going to depend on a number of factors. It's going to depend on, you know, the level of, or the state of COVID-19 in your particular region. So if you're in a region where there are a high level of cases, I'll give an example, is old care homes, for example. If there's been a breakout, that's going to be a factor as to whether or not you can refuse work. The age and health of the specific worker that is refusing, you know, to be in the workplace. Also the type of workplace, whether you're at a grocery store, whether you are at, say, a meat plant, as some of you may be aware of, or whether it's public transport. It also depends on the type of work that you're engaged in, whether you're dealing with members of the public, whether you are dealing with employees or other employees that are in close proximity to you. And another factor that comes into play is the measures that the employer has put into place. Do you have gloves? Do you have masks? Are there is there sanitation being done every day after every shift? You know, what precautions is the employer taking? And also obviously one of the main ones is has there been a positive diagnosis? Has someone in the workplace been diagnosed with COVID-19? So all of this sort of forms a factual matrix, which will sort of determine whether or not a worker or workers can refuse the right to refuse work in a work environment. And of course, as I've said already, as businesses reopen, they will be required to put some measures in place. That's just a reality now. You're going to have, you know, maybe changes in your office layout. You're going to have distance measures put into place, and you might be required to have specific types of PPE that your employees need to have. Next slide, please. And so if someone is refusing, there is a process that's in place. There is an inherent obligation for the employer to make sure that the health and safety of the workers is protected. And so where an employee has raised, you know, health concerns, or they're refusing to enter the workplace or continue working, first and foremost, it's required by legislation that you have a health and safety representative at your workplace. And that's the person you first raise your concerns to. So the initial starting point is basically internally with your employer. They have a duty to not only investigate, but also document that investigation, and specifically the refusal that an employee has raised, or a number of employees have raised, and see if there is necessary remediation that they can sort of put in place to ease the employees, you know, as a result of what's transpired. Now, if there is a continued refusal, or an employee feels that, look, I don't feel this is enough, it's mandatory that a health and safety officer or the Ministry of Labor be notified that a site visit needs to take place. And the health and safety officers or the Ministry of Labor, they have basically they're going to be dealing with what measures need to be in place. The government has rolled out a number of health and safety inspectors and officers in a number of industries, and they're expected to sort of increase the number of inspectors that they have. So you could expect where someone either has a positive diagnosis, or some employees have raised concerns with respect to what the employer is doing, an inspector will be there, and they will lay out what either remediation measures need to be taken place, or what measures are sufficient for that specific type of workplace. The inspector will typically deal with whether or not that threshold of the risk of danger, or whether there is danger in this workplace, has been met. And so that can constitute either that they say, look, you need to shut this place down, or they may say, look, these are the measures that need to be in place. or they may say, look, everything here seems fine, you need to return back to work. Next slide, please. So for services that do, or businesses that do reopen, it's important to stay proactive. They are rolling out sort of the protective measures and the distancing requirements that employers and businesses should be following. And so you need to stay up to date with Public Health Canada guidelines and the ministry instructions. And you need to be vigilant with the investigation and reporting obligations. So anytime your employee is or has, stated that there are some issues with respect to health and safety, there needs to be a process that's followed. And if it's not followed as an employee, you can make a Ministry of Labour complaint or a health and safety complaint with respect to the Canada Labour Code, and where an inspector will get involved. And of course, there are no reprisals involved. Where you report your employer for not having a safe workplace, you're protected from reprisal. They can't take action or anything against you. So you do have protections in place, and there is a process that needs to be followed. Next slide, please.
So Adele, I think that you're done with your health and safety portion of your slides. So I actually do have 2 questions from the Q&A section that you might be able to answer right now. So Jay asks, do you need to have approval from health and safety before you reopen the store? Or if you follow the health and safety rules, is that okay?
I don't think you need approval or pre-approval as long as it's one of the businesses that is allowed to reopen. So as some of you may know, there's been businesses that they've said can open for curbside pickup. And so the employees that are operating inside those businesses, there's no requirement that there needs to be pre-approval with respect to the health and safety measures. Having said that, concerns with respect to the measures that are in place. And again, you have to follow those guidelines with respect to having your internal investigation and recording it first and foremost. And then if the employee still feels that, enough measures are not in place or we are at risk, the ministry or a health and safety officer needs to get involved, and you have to follow their guidelines with respect to that particular workplace.
All right, thank you very much, Adil. So the next section that we're moving on to is that's right, accommodation in the code. So the Human Rights Code and accommodation. So I will be taking over that section now. So I wanted to start first with a note that the duty to accommodate is still in place. So the duty to accommodate and the prohibition on harassment for a protected grounds or a protected reason is still in place. So the Human Rights Code still exists in its current state. The only real modifications, so to speak, that have come up out of the Human Rights Code or human rights type issues is not so much modifications of your rights under the code, it's modifications of how those rights are protected and how you can choose to exercise those rights at your employment, place of employment or workplace in light of COVID-19 and how things have changed with COVID-19. So first I wanted to start with the employer's duty to accommodate for mental health reasons. So the employer does have a duty to accommodate an employee for mental health reasons during the pandemic, which continues. However, any requests that you make for medical kind of accommodation or other requests for accommodation based on a mental health disorder or condition that you are addressing, they must be supported by medical documentation. So this includes things like doctor's notes, things from like your healthcare practitioner, but a medical professional likely will be required to produce documentation, and then you'll be able to give that to your employer. And the reason that this is important to note is because a lot of people are experiencing anxiety and fear, which continues to linger and be ongoing, understandably so, given especially the amount of uncertainty that exists and the kinds of unknowns that is presented by something like a novel coronavirus. However, the law says that anxiety and fears alone about contracting COVID-19 are not enough to trigger a duty to accommodate. There must be something more. So there needs to be some nexus between your fear and your anxiety and a mental health disorder or other kind of mental health issue that you're dealing with that then is causing you to become now medically incapable of performing some or all of your job duties. That's why that medical documentation piece is important. So here are some do's and don'ts, or sorry, is and nots, I should say, when you're dealing with mental health accommodation and in the workplace. So the first is, as an employee, your employer is entitled to ask for that medical documentation to prove that you have a disability or require an accommodation. However, your employer is not entitled to know what your mental health diagnosis is. So they're not entitled to ask for it, and if you provide it to them, they're not at liberty to disclose that to everybody. They are required at law to keep that information confidential and private. Your employer is entitled to participate in deciding in what kinds of accommodations you receive and what accommodation plans look like. So what that is they have the ability to say, okay, you've come to me and you've said, I have anxiety about working with the public. And you have this doctor's note or psychologist's note that says, my patient will experience post-traumatic stress disorder, or their post-traumatic stress disorder will be triggered and their anxiety worsened if they're instructed to communicate with the public or be face-to-face with clients in that way. So your employer can say to you, well, if that's the case, then you can do back-end office work, even if, for example, your doctor had said, this employee should be taking a full leave of absence from work. So your doctor isn't entitled to dictate what the accommodation is going to be. So your employer and you have to work together to figure out what the accommodation will be. On the other hand, your employer is not entitled to substitute their own opinion or diagnosis over your doctors or your healthcare professionals. So what this means is if you come to work with a note that says, I have a generalized anxiety disorder, your employer can't say to you, well, I see you laughing all day, so you don't have a generalized anxiety disorder. They cannot substitute their opinion or for your doctor's diagnosis. However, your employer or your benefits provider, depending on which process you're going through, may require you to undergo a medical examination by their doctor of choice. Your privacy rights must still be maintained, and you're still entitled to experience all the regular dignity that you would normally. But this is something that you might have to go through. It depends on the circumstances, for example, what you're asking for. But that ability for both parties to be involved in the process, that's where that right comes from. Okay. And I also want to talk about accommodation plans before I move on to physical disability and family status accommodation. So an accommodation plan is a plan that you develop with your employer to accommodate your medically proven or family status needs. Accommodation plans are in place for only so long as you require the accommodation. It may come to an automatic end if your doctor's note specified an end date, or if there is a specified return to work date. Otherwise, you may request that your employer may request that you provide a medical clearance certificate in order to be able to return to work. Some other grounds that are protected include family status and physical disability. So those grounds have remained the same, but the kinds of accommodations that need to be extended as a result, that's changed. So an example here that I'm going to be using is family status. So it's already understood at law that parents may be entitled to leaves of absences to care for children, especially sick children, and that this leave of absence is a protected leave, meaning that the employer can't fire you while you're on leave taking care of your sick child. However, what's changed under COVID-19 is that you may now also be entitled to request accommodation in order to carry out your regular childcare duties if you can't find childcare, so due to daycare closures, for example. What this looks like could be, for example, modified job duties, modified requirements to be present in the office or in the workplace, modified hours, even so far as modified working schedule. So for example, maybe the parent needs to take care of their child in the morning, and then the other parent takes over in the afternoon. So you could have that employee work from, for example, 6 in the morning until 1 p.m. as opposed to their usual 9 to 5. It's important to note that one thing that has stayed the same is that it remains illegal to fire somebody merely because they are a parent, which means that if, for example, the employer has this apprehension that the parent employee will become unable to perform their job duties as a result of being a parent, but there's nothing specific that the employer can point to say these are specific actions or specific pieces of conduct that the employee has done that have led me to this decision to terminate. And they simply base it on the fact that you could become a problem or that something could become an issue down the road. That's not permitted. That's not a permitted grounds for termination. And for the same reason, it's not illegal to fire someone because you're a parent, and being a parent prevents you from doing your job at all. So while the employer has this requirement to accommodate you, they don't have to accommodate you to a point where you're not capable of doing your job whatsoever. So there has to be this balance, this give and take. So moving on to physical disabilities. So with respect to physical disabilities, the biggest one that's really come to the forefront during COVID-19 is persons who are working or employees who are immunocompromised. So an immunocompromised person is somebody who has like a predisposition to a certain kind of disease or are more likely to become infected or ill from an illness. I'm not a doctor, so that's not the medical definition of immunocompromised, but that's kind of the understanding of what it is. If for physical disabilities, if you're somebody who is immunocompromised, but you and your doctor have discussed your limitations and your doctor has determined that you can still go to work, you may still be able to request accommodations from your employer based on your proven medical needs. So your employer may be required to provide you with additional protective equipment, engage in additional safety protocols, provide you with masks or gloves at work, maybe install some of those fiberglass barriers. And again, you may be required to provide medical documentation to support your need for accommodation. This is completely normal and legal. And again, your employer is allowed to participate in arriving at the right accommodation for you and the right accommodation plan. So you and your doctor cannot dictate what accommodations are to be provided. It's a collaborative effort between you and your employer. And a note here that the employer is only required to accommodate you as an employee up to the point of undue hardship, which is the legal test, the threshold, so to speak. So undue hardship means, for example, in a lot of industries, while the employer may be required to create an accommodation, for example, install a railing on a stair, or put an automatic opener on a door, something like that, or install a ramp, the employer is not required to keep you on as an employee if on an ongoing basis accommodating you is causing them to become unprofitable, lose a significant amount of money. The test is variable, so it's really factually specific. So that means it really depends on your specific needs, your specific accommodation requests, your specific employer, and the specific industry that you work in. And the only way that we can assess this undue hardship is after reviewing all of those facts. Your employer is also not required to create a position for you if you medically cannot do the duties of an existing job at your workplace. So taking again, for example, a person who can't be around, who can't be client facing. If it's impossible for the employer at, let's say, a retail facility to find you a job that exclusively prevents you from contacting the public, and the job that you were hired to do was primarily to work with the public, your employer is not required to create like a clerical or secretarial type work for you. They're not required to create a position that doesn't exist for you. But if they can put you into an existing position where your accommodation needs can be met, then they may be required to do that. Not to displace somebody else, but if they can shift around employees comfortably, they may be required to do so. Okay, so we did have a question in the Q&A section here, and I mentioned that I was going to reference it. So I think this covers a little bit of me and Adil both. So Adil, if you just want to pay attention to this question, let's see if we can both answer this here. So Debbie's asked a question here that says, I work as an industrial cleaner in Honda. They've been called back, but I have to wear a mask and other PPE. I have asthma and I'm 61. I was on sick leave until April 20th, now collecting government assistance. Now this is my second month. I gave a doctor's note saying that I assume this is saying I would be off work until June 15th. I thought that Ford said at the beginning, if you didn't feel safe, you didn't need a doctor's note. Can I stay off if I'm not comfortable going back? So Adil, why don't you start by answering that question and I can jump in with accommodations afterwards.
Okay, so with respect to the health and safety aspect of it, so that's some very important points that you've raised there is the asthma, and you've got a medical note for it, and also your age. And so as I mentioned in one of my slides, one of the factors that the ministry would be looking at is your specific health condition, and as I said, the health and the age of the worker. So you know, you're someone that would probably need modified job duties. And so If internally you've asked them to sort of take care of that and they haven't done it, again, you can get the ministry involved. But the second thing that I can see that is that your doctor's note clearly says that you have until June 15th, and I think that touches more on the accommodations that Ivana just went over with respect to you know, medical and having the proper notes and documentation in place. And I think Ivana, you can jump in on that and put in your 2 cents.
Yeah, so if you require an accommodation, because as I just said, if you have some kind of medical disability or anything like that, and you present your employer with the medical requirements that you and your doctor have arrived at as being something that's medically necessary for you, then yeah, absolutely. So you should be able to ask for an accommodation from the employer, like we said, up to the point of undue hardship. And then what that looks like, you and your employer can collaborate on. But if you've been given a doctor's note that says that you should be off work until June 15th, then it's likely that you'll be allowed to be off work until June 15th. So if your employer is saying or if your doctor is saying there's just no way that you can be in this workplace, right, given the industrial cleaning solvents that you're likely working with, and I'm certain there's metal filings in the air and all kinds of things that would do that to you, in addition to the number of people that come in and come out of the place, right, which predisposes you to probably more severe consequences if you contracted COVID-19, then I would say that, yeah, you have a good claim to say that you're not going to be able to return to work until June 15th. And then again, just keep providing medical documentation to your employer, and you should be able to work that out there. So we're going to move on to the last section of the presentation now. So I believe that is CERB and EI and other benefits. So Adil, I'm going to put the presentation back up. Okay, so Adil, you can take it from here now.
Okay, so the Canada Emergency Response Benefit and EI, go to the next slide, Ivana. So a lot of you might already be familiar with this process. I believe it rolled out first week of April. April 3rd is when you could apply retroactively to March 15th. It's basically the emergency response benefit is over 4-week benefit periods. You're looking at up to $500 per week for a 16-week period. Some of the eligibility requirements, you must be minimum 15 years old and have stopped working related to COVID-19, or you're eligible for EI, sickness, or regular benefits, or you've exhausted your EI and regular and sickness benefits between the periods of December 29th and October 2nd, 2020. There is a minimum requirement that you receive employment income or self-employment income of $5,000 in 2019, or a 12-month period prior to your application date. And of course that you haven't voluntarily quit, so you were either laid off or there's been just a drop in business and you're not able to earn that same level of income. One of the main requirements that they're looking at, either when you first apply or as the ongoing rolling requirement, is that you cannot have earned more than $1,000 in employment or self-employment income for 14 consecutive days within that 4-week benefit period. And how you apply, as a lot of you will know, is either through your MyCRA account. You can register it online, or you can call in via phone as well. Next slide, please. So this slide, I've got sort of the periods that you're looking at, where they're going to be looking at if you're entitled to the CERB. And as I've mentioned, the main criteria is that you cannot have earned $1,000 in employment or self-employment income for that 4-week benefit period. And so where that's slightly important is where some of you may be asked to return to work, or your employer is saying, look, we're going to be giving you back pay. That's where that can come into play with respect to whether or not you will be entitled in the following period or your existing period with respect to the dates that are there. Next slide. So another important thing to be sort of cognizant of is your ROEs, your record of employment. What's supposed to be happening typically, if you are sick or quarantined as a result of COVID-19, you should be seeing what's called a code D, which is you've got an illness or an injury. But for most of you, you should be familiar with Code A. It's basically if you're no longer working due to the effects of COVID-19, so business has been down, a company's been doing temporary layoffs, those types of things. What you should be seeing is Code A, which is a shortage of work as a result of COVID-19. And now the next one, which will be relevant as businesses open up and where some of your workplaces may be asking you to come back. It's supposed to be Code E, where you've been asked to return to work, but you've refused, and it's been unlawful, so that can constitute quitting. Or Code N, where a leave of absence may apply, where it's you're taking care of someone that has or COVID-19 or parental leave and those types of things. Next slide, please. So there is a little bit of interplay between EI and the CERB. A lot of you have questions. Well, which one do I apply for? Typically, the rule of thumb is that you should go for EI first. If you don't qualify for EI or it's not possible, that's where you've fallen back and sort of applied for the CERB. And just some guidelines with respect to EI and the CERB. If you were eligible for EI prior to March 15, so before the province rolled out the emergency measures and all those things, you're not supposed to be getting the CERB. You're supposed to be relying on your EI benefits, whether they're regular or sickness benefits. If you become eligible for EI after March 15th, again, you're still supposed to be on your EI regular and sickness benefits. Now, of course, there's a caveat with that. If your benefits or your entitlements, they're done, then you can fall back onto the CERB. And typically, the way that's done is the following week of your last EI payment is where you'd be applying for the CERB. And so, as I've said, the rule of thumb typically is where you don't have an entitlement to EI is where you should be applying or falling back onto the CERB. And that's, of course, subject to those eligibility criteria that I've mentioned in the previous slides. I think that's it for my slides, Ivana.
That is, and that's actually it for all of our slides. So that's the end of our presentation of information to the public. So we do have a couple of questions that are still outstanding. So I think now would be a good time for us to answer some of those questions. So I'll start with the one that we have in the Q&A section right now. This is a question that I think Adil is best suited to answer. It's kind of a workplace health and safety question. So Marion, in the Q&A function, has asked, my employer says that they will be supplying the proper PPE when we return to work. I work in a dental office. There was a shortage of PPE everywhere, and my employer wants us to wear the appropriate PPE longer than suggested by public health, e.g. wear the mask all day, when it should be changed after 6 hours or after every patient. Can I refuse work?
So, as I've mentioned before, that specifically will depend on the circumstance of your workplace. And that's a very valid point, and you may be able to refuse work there. Specifically, I think you mentioned you work in a dental office where you are exposed to people that may not be exhibiting symptoms. And so that is definitely a concern that you can raise with your employer. They need to go through the investigative process and say, well, why, every 6 hours it does not need to be changed. And if you still feel unsafe, again, that needs to be elevated to the Ministry of Labor, and the inspector will then say, well, look, given your age and the factors in this workplace and the fact that it is a dental office, they may stipulate that, yes, you need to have it changed after every 6 hours, as you've mentioned, or they may say, look, no, that's sufficient. 1 mask per day is enough. That's really going to depend on the ministry after you've tried to deal with it with your employer. The PPE shortage that you've mentioned, that's also a very valid concern. If it's not available or the proper measures are not taking place, you may have a workplace that at first was taking the proper precautions and was a safe work environment, but over the course of weeks or months, the shortage means that, okay, well, maybe they can't have as many employees in there, or they cannot be operating for as long because there's a shortage. And that's a reality that a lot of businesses may be facing, and absolutely, but what's required is that your employer needs to address those concerns, and then certainly you can elevate it to the ministry for them to step in and say, look, you're a dental office, this is what actually needs to be in place with respect to PPE and the distancing and those types of things. And that's a great question, and you've got some valid concerns there that do need to be addressed.
All right. Thanks, Adil, for that answer. I hope that answered your question. So I believe we have 2 more questions now for text. Okay. So the first one we have from an anonymous attendee here. It says, is there an obligation as an employer to pay employees who say they have COVID-19 symptoms? If yes, for how long? So does anybody have the answer to this question? I may know the answer to that question because I've asked it myself.
I think you can jump in, Ivana.
Okay. So no, there is no obligation for you to pay an employee who says they have COVID-19 at law. And the reason that I start with at law is because in Ontario law right now, there's no requirement that employers provide their employees with paid sick leave. So that's where we start. That's the first thing. So we're talking about the Employment Standards Act. Where that may differ is kind of really, it's from the employment contract. So if the employment contract provides your employee with paid sick time or the access to short-term disability, long-term disability benefits, that's a different conversation because now we're talking about how they access their paid sick time, how they prove that they're entitled to the sick time. So going back to the Employment Standards Act, when we're talking about proof about sick time, if there's no right under the employment contract for this employee to take paid sick leave, if the employee would like to take a leave of absence because they're ill for COVID-19, under the Employment Standards Act, they don't have the right to take more than 3 days of sick time, which is unpaid again. But if they can prove to you that they have COVID-19 and either have been quarantined by a medical doctor or have been directed by public health to quarantine or for any other reason have to self-isolate, that's a different kind of leave. So if you're just talking about somebody who says they have COVID-19, you can request that they provide to the best of their capabilities proof that they have COVID-19 or have been directed by a medical professional to take the necessary steps to prevent themselves from being in public, self-quarantine, along those lines. And that right to request that medical documentation comes from the Employment Standards Act too. So under the Employment Standards Act, you have the right as an employer to ask your employee to provide proof, medical documentation, doctor's notes, testing results, whatever, that supports that they are in fact sick as they've alleged. And Francis, I see you nodding along. Do you have anything that you want to add?
Oh, you covered pretty much everything.
Sorry.
I'm just like, yep.
So Francis, part 2, I think, of this is if yes, for how long do you have to accommodate them? So why don't you go ahead and answer that question?
Yeah, sure. So in terms, if an employee has been possibly exposed to COVID-19 and needs to self-quarantine, that would depend, actually. It's under the specific section, the emergency leaves, where an employee is entitled to an unpaid leave for however much time that they need to recuperate from the COVID-19. And just like Ivana did mention earlier, the employee does need to provide some sort of evidence, such as medical documentation, any proof that they do actually have contracted it in order to self-isolate. All right,
sounds good. Thanks, Francis. So we have another question here from Jay in the Q&A section. I think this might be best for Adil to answer. So Adil, Jay asks, is anyone who has less than a $5,000 income in 2019 still able to apply for CERB?
I mean, it's a pretty straightforward application process. They ask that when you're applying. So if you haven't met that minimum requirement, you're either going to be indicating that you meet it and the application will go through, in which case you're going to get in trouble when they find out you didn't have that minimum income. So, I mean, technically you can apply, but it's going to get you in a lot of trouble. So the way I've seen it is that it's a requirement when you go to the application page. It's got the criteria there, and you're basically making a statement that these are all true and I'm not falsifying that information. So you want to be a little bit careful with that requirement.
Yeah. It sounds like it's a pretty cut and dry answer. So yeah. So likely not. We don't think so. Okay. So I have another question here that says, do we have any insurance that CERB or EI for people who stay home just to be on the safe side will be provided since they don't want to get infected from the virus? So this is a question here that says, really, a person who wants to stay home, even though their workplace is operating and offering them employment, are they allowed to claim CERB and stay home anyways? So I think we all know the answer to this. So Francis, why don't you go ahead with the answer?
So there's a pretty fine line. So it's either if you have contracted the virus, then you may be entitled to short-term or long-term disability. But if you are just trying to protect yourself and your employer has provided the proper PPE, has implemented many safety precautions in preventing the spread, and in addition that they actually have, say if you have been temporarily laid off and you have been recalled to work, there is a duty to return to work. And if you do refuse to return to work and all of these measures, safety measures have been implemented, it may be seen as abandonment of job and something called just cause for dismissal.
Okay, that's great. Thanks, Francis. I think we've answered all the questions that have been asked. So one that I answered in the text back here was a question we had from a gentleman named Jay. So Francis, this is probably a good question for you as well. So the question asks here, as an employer, do I have to issue a job letter or when we hire an employee, or is a job duties assignment contract, is that sufficient?
As in if you lay off an employee?
When they hire. So do they have to issue a job letter when they hire?
If you're saying like a job letter that you have been, if you got the position, yeah, it is important. But if you are asking the question as if should an employer provide with a written employment contract, then yes, that should be strongly advised, because we would want almost everything and anything in writing. It also helps to outline exactly what the employee would be entitled to, such as wage compensation, any duties that they need to do, also termination clauses as well, and possible temporary layoff clauses as well. It helps to exactly define what the employment is between you, if you are an employer, and the employee.
Yeah. So those are all good reasons to include a employment contract. But at law in Ontario, you're not required to provide a written contract of employment, right?
Yeah. It's not required to provide a written. It can be verbal. But that's where there's going to be a lot of miscommunication in terms of if there's a possible termination at the end, where one person is being terminated, whether it's for cause or without cause. And if it's without cause, it may expose the employer to possible wrongful dismissal lawsuit at common law, which during the presentation I mentioned that common law reasonable notice is much greater than if it was employment standards reasonable notice.
So tons of good reasons to ensure that there's an employment contract in place. All right. Adil, we have a question that's come up for you now. So Hanan asks, is an employer required to provide PPE equipment to employees that are considered essential? For example, grocery store cashiers. Is an employer required to provide them with PPE?
Yes. I mean, if you've been to the grocery store, you've seen the plexiglass that's been up, you've seen the distancing measures that they've put in place. There's sanitation requirements as well. And then again, the requirements with respect to masks and gloves as well. I think with essential services, the public, as I've said, Public Health Canada has laid out the guidelines. That's what you need to be following for specific essential workplaces. And the other example I'll give, I think, is with respect to hospitals and nurses and whatnot. They actually require the face shields. So yes, it does vary depending on the essential service and the industry that you're in. Whether a mask is required for other businesses as they open up, that's going to be a case-by-case basis depending on the workplace itself and sort of the level of interaction between the employees and members of the public. So I hope that sort of answers your question. And again, at any point where you're being asked to return to work, all you have to do is ask the question, okay, do we need face shields or do we need masks? Do we need gloves? What type of sanitation is taking place? If you're not satisfied with those answers, you go to the ministry and that's fine. They'll get involved and they'll say, look, for this workplace, this is enough. Or for this workplace, this is not enough. This is what you need to do. Otherwise, we'll shut it down. So there is a process that needs to be followed, as I've mentioned. And as the province opens up, that process will be followed, and as measures need to be either added or changed, that's going to happen with respect to the guidelines that Public Health Canada issues.
All right, thanks, Adil. And you mentioned that the Government of Ontario has rolled out specific return to work guidelines for different industries, right? Like, so the Ontario government did that a couple of days ago. They rolled out literally like return to work. Yeah, guidelines. Okay, wanted to make sure that was covered. All right, I have 2 more questions here. So Francis or Adil, do either of you know a lot about vacation leave allotments, those kinds of vacation leaves, or is that something I should cover?
I can cover it, yeah.
Okay, so we'll give it a shot with Francis.
Yeah.
So Francis, in the Q&A section, Tom has asked us, with no collective agreement in my workplace, as an employer, can I limit vacation this summer as most employees are not taking vacation right now?
So in terms of this, it depends on your, well, first and foremost, the employment contract and what are the employees currently right now. Are they on temporary layoff? Are you paying them at work? Are you currently open right now? There's a few other factors to determine that. But in terms of vacation, the employer does have the ability to determine when an employee takes vacation. So if all of your employees are determining to take vacation in summer, then there's obviously going to be a possible impact on your actual business and the ability to receive revenue. And the employees are essential to maintaining that revenue. So yes, an employer can determine when the employee takes their vacation. The thing is that if there is an employment contract and the employee is, say, for example, they are for every year of service, say for an employee who has 1 year of service, they have 3 weeks vacation. If your employee has 3 weeks vacation, they are still guaranteed those 3 week vacations. So you can't minimize that to say 2 weeks because during this time they're off work. They are still entitled to the 3 weeks if so. But if there is no talk about vacation, then you would also have to rely on the employment standards, which determines that for every an employee with at least 1 year of service is entitled to two unpaid weeks of vacation, dependent on how your vacation pay is paid out, which is it's a different topic, but essentially, yeah, they are entitled to 2 weeks. And if you want to reduce that, unfortunately, you will not be able to because of the fact that they are still entitled to 2 weeks.
Yeah. And I actually recently learned that vacation pay can be paid out at any time as long as the employee and the employer agree to it. So that might be something that you want to take to your employees as a bargaining tool and ask them, listen, if I pay this out, will you come back to work on a couple of days, something like that. So that's if you obviously don't pay vacation pay during each paycheck, which is a way that you can pay an employee's vacation pay too. All right. So I have a question here from Mary. So Mary asks, hi, my employer who I worked for 21 years sold his practice, and the new employer said they will take on the original contract. So does that mean that I have 21 years of employment or less than 1 year of employment since they took over? Does anybody know offhand the rules about seniority and continuity of employment upon sale of business?
I believe it's continuous. It's as if, say, if your employer, or if you're employed in one company and then somebody else entices you from a different company and then you work for that company, and then if you become terminated without cause, there is that continuity. So yes, there is a continuity of your previous employer who employed you for 21 years, and then this new employer has taken the contract. It would essentially, it will continue, essentially. Your seniority of 21 years will continue.
Yeah, I checked. It's section, in case you're curious, Mary, it's section 9(1) of the Employment Standards Act, which is under part 4, literally called continuity of employment. So Francis, bang on, that's it. So you will be continuing your seniority. So it's 7:49 p.m. right now. We've run out of both text and chat questions. If anybody has any specific questions they'd like to ask, you can use the raise hand function right now to raise your hand, have your video and your mic turned on, and then you can audibly ask us any questions that you may have remaining. I'll give it about a minute or two for people to get back on the app, ask their questions, raise their hands. But if we don't get any more questions in the next 20, so to speak, minute or two, then we'll probably wind up the webinar. We always leave a lot of time at the end for questions, just in case people have specific questions. I mean, you've come here and you may as well take advantage of having three professionals who know a little bit. Look at it. Did you see Adele? Adele's like, I am a professional. You may as well take advantage of us while we have some time available. So I'm going to give it about 20 more seconds, and I'm going to check on. I think we have one more question in the Q&A section. Oh no, just a thank you. I also wanted to mention that you may now see that the PowerPoint is down, that we have a logo here that says KPA Lawyers. So although there's 3 of us presenting right now, there's actually 4 of us on the civil team. So that's the team that does employment, labor, anything kind of generally where people have problems with each other, kind of interpersonal problems, not divorce and not family law. So the 4th person here under the KPA logo is our partner, Ryan. So he manages the civil team, and he's also our IT guy. Ryan, do we have any questions that are being asked in the background, or any hands that are being raised, anything like that? I see that we have no hands that are being raised, so thank you. All right, I think that's probably going to be it for the webinar for us then for today. So thank you everyone who participated today. We're glad that we could help you out. For anybody who's asking if we're going to share the presentation, we're going to post the recording of this webinar on our Facebook page, so you'll be able to access it there. And if you need to download anything like the slides or anything, you can just you can look at them again at that presentation. So thank you very much. Have a good night, everyone, and take care.
Have a good night.
Good night, everyone.